Morning, Your Honor. Attorney Benjamin Stolman, appearing on behalf of the City of Burton.
Thank you. Mr. Renfro, if you would state your name.
Christopher Allen, House of Renfro.
Thank you. Today is the date and time set for a jury trial in the misdemeanor matter in this case, and then we also have the 2 civil infractions that I plan to handle after we finish with the jury trial. I just wanted to have a short pre-trial to ensure that we are ready to proceed on that jury trial. And so, Attorney Stolman, are you ready to proceed today with the jury trial?
Yes, Your Honor.
Okay. And Mr. Renfro, are you ready to proceed today on the jury trial?
I'm always ready to defend myself, but I still do not consent. I still do not consent to these trials. These are done on fraud for the tickets were what initiated the stop, and now you're trying to get me on a crime that hasn't even been, we haven't dealt with the initial problem here. So until that's dealt with, how do we know if I committed a crime?
All right, well, one, I'm not trying to get you on anything that's not, stop, I'm not finished. Mr. Renfro, you stopped speaking and then I started speaking, and to be honest with you, it doesn't really matter. When I start speaking, everybody else stops. That's how court works. I've already warned you of that multiple times. So don't test me today, because we're gonna be in front of a jury, and if we start doing it in front of a jury, like I've also told you before, it's not going to happen. I will excuse them, we will have a conversation, and I will hold you in contempt, okay? As I was
Today's case is a textbook example of what happens when sovereign citizen ideology collides with an actual jury trial. We're in Michigan, where Christopher Allen Renfro, who identifies himself as the House of Renfro, is about to represent himself in a criminal jury trial, despite repeatedly rejecting the legitimacy of the very court he's standing in. This hearing is supposed to be routine, a short pretrial check to make sure both sides are ready. Instead, it turns into a masterclass in judicial authority, courtroom procedure, and what not to do when facing a jury. Watch closely, because the judge lays down hard boundaries, explains jurisdiction in plain English, and makes it crystal clear that disruption will not be tolerated. There are warnings here, consequences being outlined, and moments where this case could spiral fast. Stay with it, because the tension only builds from here.
I'm not trying to get you on anything. I'm the court, prosecutor's office, files charges. There's 1 misdemeanor charge. There are 2 civil infractions. You will have the opportunity in your trial to question the officers and to have those questions answered that you have about why you were stopped and et cetera, et cetera. That's why we have the trial, and that's why we're having the trial. I am well aware that you do not consent to these proceedings. I am well aware that you don't think the legal process in and of itself is legitimate, but the simple fact is that it is, and you are supposed to be here, and we are moving forward with this case today. So what we will do is this. Now that we've established that everybody is ready to go on the jury trial, I will let the jury board know that we are ready and that we are proceeding today. So anyone who has witnesses that need to be here, make sure that they are here. Make sure you have all your documentation in order. If there are any exhibits that the parties wish to present, I would appreciate if you at least try to exchange those exhibits in advance. I know this is a little bit more difficult case than some others, but at least try to do that. And let the other person know. Maybe there could be a stipulation or not, that's okay. And then the last thing before we take a break, which is what we're gonna do, we're gonna take a break so that we can handle the rest of the cases that are here, and then we'll start the jury trial. The issues of jurisdiction, I've already ruled that this court has jurisdiction. That's not an issue that gets brought up in front of the jury.
I have a right to.
Don't.
Right here, the tone of this entire case is set. Renfro immediately leans into the classic sovereign citizen playbook, I do not consent, claims of fraud, and arguments that the court lacks legitimacy. But notice what the judge does next. She doesn't debate ideology. She asserts authority. This is crucial. Courts don't operate on consent, they operate on jurisdiction and law. The judge makes it clear that interruptions won't be tolerated, especially with a jury involved. That warning is not casual, it's strategic. Jurors watching a defendant talk over a judge would instantly damage his credibility. This moment is the court saying, you can defend yourself, but you will follow the rules. And that distinction matters more than Renfro realizes.
You can object to evidentiary hearings, or evidentiary hearing issues. You cannot object to jurisdiction in front of a jury. If you do it, I'm going to excuse the jury, and I'm going to hold you in contempt for not following the rules of court. These are not my rules. They are the rules of the courts of Michigan. In this big book here that I hope you've read, because you're getting ready to start a jury trial, and I really hope you've read these because it's the court rules and the rules of evidence, and you need to know these things. Because if you don't do it right, I'm not going to give you any leeway on that. We've already talked about this. One more time, Mr. Renfro, are you sure that you do not want to speak to an attorney about this matter before you move forward?
I'm sure. Actually, I do not have my discovery for the case. I haven't been able to go over the evidence. It has not been served to me. I do not have the police body cams that I've requested a long time ago. I paid for half of them, have not received them. I've not been able to go through any evidence where they're trying to get me on crimes before the initial stop was a civil infraction and somehow bred a crime out of that. It's an unarrestable offense, the civil infraction. You cannot, that's fruit of the poisonous tree. So now we're here on crimes taking care of the initial problem. So the tickets have to be first, and we're not moving anywhere until we get that clear. And you're in improper jurisdiction, subject matter jurisdiction, and personal jurisdiction. And we're not going to move nowhere until we get this taken care of. I demand this court to vacate these matters. I say vacate, you say dismiss. Vacate these matters immediately.
Done? One, I've already said that I'm not going to vacate, and dismiss is the right word.
This is one of the most important legal moments in the entire hearing. The judge draws a hard line between legal issues and jury issues. Jurisdiction is decided by the court, not debated in front of jurors. Because juries decide facts, not whether the court exists. Renfro repeatedly tries to blur this line, but the judge shuts it down cleanly and correctly. She even explains that raising jurisdiction in front of a jury will result in contempt. That's not intimidation, it's enforcement of court rules. Viewers should understand this clearly. Refusing to follow procedure doesn't make an argument stronger, it makes it sanctionable.
I already said that. Two, I've already said that jurisdiction is appropriate. We have subject matter jurisdiction in this matter. We also have personal jurisdiction. Subject matter jurisdiction is because you're in a criminal court in the state of Michigan. And that is what we are dealing with. In fact, it's a misdemeanor, so you're in the right criminal court being district court. So we have subject matter jurisdiction. We have personal jurisdiction over you because it alleges that this matter happened in Burton, and Burton is in the jurisdiction of the 67th District Court. So we have both personal and subject matter jurisdiction. Those issues are laid to rest. If you want to bring them up again, you can bring them up on appeal. You will not bring them up again in this hearing because we are getting ready to start a jury trial, and those are issues that are not appropriate to bring up in front of the jury. And as far as your issues of civil infractions leading to misdemeanors, happens all the time. All the time. And it is legitimate as established by our Supreme Court. So you can say that if you want to, but your argument is inaccurate. Once again, Mr. Renfro, your argument is inaccurate. You didn't answer my question. My question was, do you want to speak to an attorney before you move forward?
I'm a competent man.
It's a yes or no?
Lawfully competent man, no.
No. The answer is no. All right, I've asked you that question many a times now. I don't feel like I need to ask it to you anymore. You've established very clearly that you're going to represent yourself in this matter, for better or worse. Attorney Stoltman, do you have anything that you would like to say in regards to any of the issues that Mr. Renfro has brought up?
Judge, I know he has not made a demand for discovery or request for discovery. I'll give him another copy of the police report, which is the only thing he's asked my office for. I'll have another copy. I believe he has made a FOIA request to the city regarding documents. I don't know whether or not that request has been granted, but I don't believe the FOIA request was all.
This is the moment where the judge gives Renfro every possible opportunity to protect himself, and he refuses. She explicitly warns him that she will give no leeway on rules of evidence or procedure. That's critical. Self-representation is a right, but it comes with serious risks. Courts are not allowed to coach defendants or save them from mistakes. When Renfro insists he's a competent man, he misunderstands competence versus legal training. The judge's repeated offer of counsel isn't weakness. It's the court ensuring the record shows he knowingly chose this path. For better or worse.
Relevant to this case, I believe it was for more documents.
And I believe, Mr. Renfro, you've stated that on the record previously, that the body cams, or whatever those were, that you FOIA'd them. The prosecutor's office is required to turn over to you all of the evidence that they have and all the evidence that they plan to use, and they have done that. We've had discussions about discovery numerous times. We're not going to delay the trial any longer. So we're gonna have this trial today. Okay.
We have no exhibits that we're planning to introduce. We're just gonna have the testimony of the officer and Mr. Renfro if he chooses.
Okay. Are you trying to say something?
Is the warrant in here? I don't see the warrant. Or the,
This is the second time you've been given those documents. Do you have the warrant from last time? Or the other time that someone gave you that?
I've asked this court numerous of times for the discovery.
Here we see the legal buzzwords start flying. Fruit of the poisonous tree, civil infraction, subject matter jurisdiction. But using the right phrases doesn't mean they apply. The judge patiently dismantles these claims, explaining that civil infractions routinely lead to criminal charges and that Michigan law explicitly allows it. This isn't opinion, it's settled law. Renfro's real issue isn't missing discovery, it's misunderstanding how discovery works. FOIA requests are not criminal discovery, and refusing documents earlier only hurts him now. This is a cautionary moment for viewers. Misunderstanding procedure doesn't invalidate
I
it.
have to have it to fight in the trial. I have to have the exhibits to be able to see what's going on or the moves that were made to get me in this position. So that
Answer the
warrant,
question, Mr. Renfro. The question was last time when they delivered to you the discovery after you refused it, because you actually said you didn't want it because you were confused about how the court rules work. You got the discovery. Did you get the warrant in that discovery? It's not necessary,
I didn't
just so
get
you
the
know, but I'm gonna
discovery.
make sure that you have it. Do you have it or not?
No.
Okay, the answer is no. So here's what I'm going to do, unless there's an objection. I am going to provide the statements for probable cause as well as warrant and complaint copy out of the file. So Mr. Renfro has that. He doesn't have any complaints about not having it. Mr. Our Attorney Stolman, do you have any objection to that?
No.
Okay, all right, so we'll make a copy of that. Mr. Renfro?
Hello guys, I'm doing trading live now guys. Hmm.